ఎస్సీ/ఎస్టీ వర్గీకరణపై సుప్రీంకోర్టు కీలక విచారణ జరుపుతోంది. సుప్రీంకోర్టు ప్రధాన న్యాయమూర్తి జస్టిస్ చంద్రచూడ్ నేతృత్వంలోని 7 న్యాయమూర్తులు రాజ్యాంగ ధర్మాసనం నేడు కీలక తీర్పు వెలువరించనుంది. రాజ్యాంగ ధర్మాసనం విచారణను లైవ్ లో చూద్దాం.
There are as many as 6 opinions in the case. I have authored an opinion for Justice Manoj Mishra and myself. Justice Bhushan R. Gavai and Justice Pankaj Mittal have authored separate concurring opinions. Justice Gavai and I have agreed with each other's conclusions. Justice Vikram Nath and Justice Satish Chandra Sharma all have agreed with the opinions of Justice Gavai and myself. Justice Dela Trivedi has dissented. The majority of us have overruled the judgment in E.V. Chinnaiah. We have held that subclassification of the scheduled caste for the purposes of reservation is permissible. I'll just read out a brief extract. In state of Punjab versus Davinder Singh, the Constitution bench held that the judgment in Chinnaiah requires to be revisited by a larger bench of 7 judges because it failed to consider significant aspects bearing on the issue of subclassification of the scheduled caste. Deciding the correctness of Chinnaiah, the following issues fall for our consideration. A. Whether subclassification of a reserved class is permissible under Articles 14, 15 and 16. B. Whether the scheduled caste constitute a homogeneous or a heterogeneous grouping. C. Whether Article 341 creates a homogeneous class for the operation of the deeming fiction. And D. Whether there are any limits on the scope of subclassification. The Constitution's 77th Amendment Act 1995 included Article 16(4)(a), enabling the state to provide reservations for the scheduled castes and scheduled tribes in promotions. The Constitution 82nd Amendment Act 2000 added the proviso to Article 335 stipulating that lowering the standards of evaluation will not be inconsistent with the maintenance of efficiency. The amendments recognize the difficulties and struggles faced by members of the scheduled castes and the scheduled tribes during promotion. In a formal sense, the criteria of selection for promotions a priori excludes the members of the scheduled castes and scheduled tribes because the criteria which are considered to be appropriate are not accessible to them. In a more informal but substantive manner, the members of the scheduled castes and the scheduled tribes are often unable to climb up the ladder because of the stigma of incompetence held against candidates who are selected through reservation. The stereotype operates against them because they are externalized as affirmative action beneficiaries or quota candidates. The amendments recognize the discrimination through the operation of both human conduct and recruitment processes. They are an emphatic repudiation of the binary of reservation and merit. Article 14 of the Constitution permits subclassification of a class which is not similarly situated for the purpose of the law. The court, while testing the validity of subclassification, must determine if the class is homogeneous and an integrated class for fulfilling the object of the subclassification. A class which is not integrated for the purpose can be further classified upon the fulfillment of the 2-pronged intelligible differential standard. In Indra Soni, this court did not limit the application of subclassification only to the other backward class. This court upheld the application of the principle to beneficiary classes under Articles 15(4) and 16(4). Article 341(1) does not create a deeming fiction. The phrase deemed is used in the provision to mean that the castes or groups notified by the President shall be regarded as a scheduled caste. The inclusion of the word deemed in Articles 341(2) and 342(2) does not create a legal fiction, since it does not provide any artificial construction. To that extent, the observations of the 3-judge bench of this court in Puneet Rai versus Dinesh Chaudhary that Article 341(2) creates a deeming fiction are erroneous. Even if it is accepted that the deeming fiction is used for the creation of a constitutional identity, the fiction can neither be extended to other purposes, nor can it create legal consequences that do not logically flow from the fiction. The purpose of the deeming fiction, even if one is assumed, is identification of castes which are the scheduled castes. The inclusion of certain castes within the scheduled caste category is only to demarcate them from other castes which are not included in the category. The inclusion does not automatically lead to the formation of a uniform and internally homogeneous class which cannot be further classified. Subclassification within the scheduled castes does not violate Article 341(2) because the castes are not per se included in or excluded from the list. Subclassification would violate the provision only when either preference or exclusive benefit is provided to certain castes or groups of the scheduled caste over all the seats reserved for the class. Historical and empirical evidence indicates that the scheduled castes are not a homogeneous class. A. The depressed classes were identified based on the notion of untouchability and not in the literal sense of the term. The effect of adopting the notional and not the literal test is that the social condition of all the castes included within the depressed classes is not uniform.